This discussion with Howard Madelon of the law firm Olender Feldman took place during a T Equipment webinar held on November 17th, 2020. In this discussion, Howard goes into detail on new COVID-19 legislation and the liability it creates for employers throughout the U.S. Please note that this discussion is for general informational purposes only and is not intended to constitute legal advice.
So, good afternoon, everyone. My name is Howard Madelon. Thank you for that gracious introduction, Evan. We're going to be talking today about COVID-19 legislation, how it's shaping things and creating new liabilities for everyone. So, very quickly, just who we are, so that you know that I just didn't walk in off the street. My firm, Olender Feldman, is in Summit, New Jersey. We're a middle market firm. We service virtually every practice area that a business could want. I am the head of the Employment Practices and Employment Litigation Group. My particular area of expertise includes the hires wheel, which is an acronym for all of the phases of the employee life cycle and how you manage your capital assets. The four primary areas of my practice are HR auditing, compliance and policy guidance, retention and risk mitigation to retain your employees and the ROI that they represent for your business, and then in the unfortunate situation where you have litigation, to be able to help you manage those crisis points. Let's talk briefly about where things stand today, because it's quite remarkable. I used to put on slides that just talked about where restaurants were open. Now we're talking about COVID cases. This slide, which I found last night, was just horrifying to me. To see that there are 60 daily cases per 100,000. We have an added million cases. We're at, I believe, 11 million cases in the United States, 180,000 just added yesterday. And governors trying to scramble in the midst of a political situation which seems to be resolved. And we will be talking about that shortly, because looking in our crystal ball, what a President-elect Biden administration is going to do and what kind of COVID legislation we're likely to see is an important aspect of understanding what you have to do as a business to manage through the changes, the ever-changing environment of COVID. So for those who have been following politics closely, you probably know that whatever it is that the CDC and OSHA have been doing have been largely quiet. And the reason is because President Trump played down the pandemic, particularly with the CDC. Most of what was proposed by the CDC came in the form of what we call guidelines. Guidelines are not enforceable. Guidelines are simply, effectively, suggestions. There's no regulations that come with them. That is very likely to change. As President-elect Biden asserts himself in the new focus of his administration, the task force that he's now formed, and the fact that he likens himself to a wartime president when it comes to COVID vaccinations and testing, we're going to see something very similar to what Woodrow Wilson did way back when he had a wartime commission formed for the purpose of addressing production within the United States. We will see mass use become a federal requirement for the first time. We will also see free testing circulated around. Unclear whether the federal government's going to foot the bill entirely, whether they're going to put the force of the bill on the employer, or where it's going to come from. But this slide really sets up 2021 nicely for where it's going to go. Vaccinations are going to be a major part of our lives next year. I guess there's a blessing and a curse to that for employers, and we'll be talking about that as well. So President-elect Biden has talked about new stimulus measures, more checks coming to employees, to struggling businesses, and so forth. For those who followed the debate on the second stimulus package, we know that there was a stark gap between the House and the Senate in their stimulus bills. And after we get the Georgia results, we'll know how likely it is which of the two types of packages or some kind of consolidated package is likely to pass. So what are things on a national scene? We have closure, suspension of almost all indoor gatherings starting to happen around the country. That is certainly the case in New Jersey. California has now moved many of its most populous counties like Fresno County into what they call the purple tier, which means that its maximum restriction, retail businesses are outside only. You'll see deliveries, but no indoor dining there. Similarly, in New Jersey, indoor dining is all but gone. Indoor gatherings limited to 10, and apparently you can't sing during Thanksgiving. But that's where we are in New Jersey. And I'm using New Jersey and California as kind of my benchmarks because while we're on opposite sides of the coasts, it appears that a lot of the states are looking to see what New Jersey, New York, California are doing in order to determine where they want to go, where they want to slant themselves. And interestingly enough, you have cities like Chicago, which are undergoing a remarkable surge of COVID. 1 in 18 residents has COVID. And their stay-at-home advisories are basically, unless you need to be out and about at the grocery store or the pharmacy, we want everyone to stay at home. I don't think we've seen anything like this in the United States. It's quite a remarkable time for some of the cities. I know Philadelphia is now tightening all of their restrictions as well as to whose homes you can go to. Virtual business operations are here to stay. Governor Murphy is not touching any of those. For an example, in New Jersey, we had the recent passage of Executive Order 192. We're going to talk about that in a second, which requires daily testing of health conditions, but no specificity on exactly how that daily testing is going to be put into effect. He's apparently leaving it up to the individual businesses to decide that, which has caused no end of consternation for our clients. But what it does tell us and reminds us is that policy-driven guidance, the kind of guidance that you get from your HR professionals, is really critical right now, and it should be implemented for all your health and safety concerns within your workplace. So what does Executive 192 say for those who haven't followed it closely? Mask use is mandatory in businesses. Declination of access, if you are a customer-facing business, will become part of the standard, provided, of course, that you adhere to the Americans with Disabilities Act and you also adhere to the New Jersey law against discrimination. Disclosure of known exposure conditions is still remaining subject to the Americans with Disabilities requirement and state law variants. Daily health screenings and what you do with the information attendant to those screenings is going to be a major problem as we move from the fourth quarter of this year into 2021. And of course, the big issue will be vaccinations. Can employers require them? Will employers require them? And what are the pitfalls of that? So let's talk about compliance policies and procedures, one of my favorite topics because it's all about risk mitigation. My practice is all about the human capital asset being the most valuable asset your business has. It's the only asset capable of appreciating in value, but employers could also ruin those assets and depreciate them radically, and nothing does that more than not resolving the fear factor of COVID and the implications of COVID for your workplace. These are the issues that all employers should be thinking about. The guidelines that are proposed, and the most important of those, as we'll see in a moment, are actually the EEOC guidelines. Developing your health and safety protocols and policies in written form, not simply verbal education or emails. How you communicate with your employees is critical, and addressing what the case-by-case COVID issues are and the new liabilities that are attendant to those issues. So for those who have been paying attention to the federal agencies involved, the most fascinating thing is that OSHA has been least involved, and yet they are normally tasked with dealing with these health and safety issues. I took a look last night at the OSHA page talking about all their compliance actions. I would say roughly 75% of them are all directed at nursing homes and health facilities. Um, they are sporadic in nature, starting with virtually none back in March and April when the First Families Coronavirus Relief Act hit and the CARES Act came into place, to where they're at an all-time high. Someone, lit a fire under the organization, and yet they still are using guidance that I've put on the screen, 339003 and 3994. Um, these documents, respectfully, are documents that most of your kids know. There's nothing more in these documents than anyone's household is aware of today. It's very poor and stale. None of it really addresses any of the things that all of you are really concerned about. And ironically, all it really takes is a call to OSHA to get them involved. Interestingly enough, there's been a couple of federal litigations filed by the unions against employers, and the courts have come back almost uniformly and said, this is an issue for OSHA to manage if OSHA wants to manage it, but the employers, if they're taking basically reasonable measures, are free from suit. They also tried to sue OSHA, by the way, and that was unsuccessful. The document on my right, which is an older copy of what's out there now, is currently, from my perspective, the Bible on all things COVID when it comes to an employment situation. Why? It's the most updated form of document that exists on a federal level. The federal government in the EEOC, while not doing too much in the enforcement side of things, has been extremely active in setting guidance based upon first family coronavirus relief and what to do during the pandemic. Most of the things you're going to see on the left side of the screen are things that I assume everyone knows. You can measure body temperature. You can require employees to stay home. Interestingly enough, in a split decision, you can require COVID tests as to whether somebody has active virus, but you can't actually test for antibodies, which is another way of saying test for people who have it as to whether or not they still have it in their system as an antibody. First of all, the antibodies aren't a reliable measure that you can't get COVID. It's been proven that you can get COVID again, but also because it constitutes a medical condition, a medical examination, excuse me, it would be a violation of the employee's rights to insist on it. Reasonable accommodations continue to be a very, very important factor in most businesses' lives. Even though the ADA only applies to businesses over 15, that is not the case when it comes to the First Family Coronavirus Relief Act, which applies to all employers under 500 employees in number. So if you don't know what the reasonable accommodation standard is and you don't know how it applies, it's really critical that you grab your employment attorney and talk it through. The new risk analysis is whether there's a direct threat presented by the employee, what the employee's concerns or considerations are in not wanting to return to work because of a various set of medical issues, which could be anything from age to a certain weight class to immunocompromised conditions. They may have a doctor's note about wearing masks or coming into the workplace. Every single one of these issues must be addressed. Any employer who ignores a legitimate concern proceeds at its peril. The one thing that the EEOC will get all over is violations of the First Family Coronavirus Relief Act. I can tell you that several of my clients have come under audit. These are specialized audits. These are FFCRA audits. They are not wage and hour audits, but the power of the federal government to audit all of your books and records through an FFCRA audit is extremely powerful. The only thing you basically can do is force the government to accept the premise that nothing existed as far as FFCRA before April 1, and therefore you can't look back before that. But it is a problem. They are fishing. P.S. For those of you who got your CARES Act relief, I can't think of a more beautiful way for the federal government to find out everything about your business than applying for a loan. They know all about you now. Reasonable accommodations includes both whether there's a family member issue for the first time and an individual issue. And let's keep in mind the undue hardship standard for those businesses that have a few number of employees and they can't stand to have their COO out if it will present a significant difficulty or expense, such as a loss of income or a serious restriction on employer operations, then you absolutely can deny an accommodation. Accommodations have been denied under FFCRA, for example, in childcare, where having so many employees out would work such a disservice on the business that it threatens or imperils the existence of the business. Hiring or onboarding, another area of liability. You can screen applicants for COVID. You can take temperatures or conduct some kind of exam as a precondition of employment. You can ask them to get cleared by a doctor, in other words. You can delay start dates and withdraw job offers if there's symptomatology associated with it, but you cannot delay it based on any of the protected classifications, which is why telework has become such an attractive alternative where possible to working inside physical operations or offices. And again, keep in mind the EEOC requires you to keep medical information and test results separate from the standard personnel files. If you are testing for temperature, for example, or daily screenings, you should have that information kept separate and apart from your standard personnel files. Everyone knows about the new work processes. I'm sure everyone here is familiar with what's called a health or safety verification, but we're going to talk about that next, about temperature checks, protective gear. I can tell you that almost all the retail businesses I've been to in New Jersey are doing some form of one or both of the other, even before Governor Murphy's edict about using them. And I'm sure everyone understands what social distancing measures and cleaning and sanitization are like. But if you don't, Executive Order 192 actually codifies all of those methods. And it would be probably a good idea for you to look at them. So I want all of you to be asking yourself, this is obviously rhetorical, what are you doing to record, measure, or test for COVID symptoms? What are you doing, if anything, to do contact tracing? What are you telling other employees if, God forbid, COVID hits you with an outbreak? You should be asking yourself these questions. I'm sure most businesses have obviously resolved the issue by now of the physical presence. But what I've learned as COVID wears through the process, a number of companies are finding that they are not able to operate effectively through video or Zoom and are insisting that employees start coming back to the workplace because the teams are more effective together or the individual is not effective outside of the workplace. We're going to see these issues hit a flashpoint this quarter and next quarter. What do you do about employees traveling out of state? What do you do with logistics businesses where the companies are insisting that they come into areas, health protected areas, where COVID may exist? We've been talking since April when the COVID outbreak first hit the FFCRA that if you don't have an operations manager or an HR manager or both, you really need them now, because this is too important in terms of how you manage through COVID, what you do in the event of a crisis such as an outbreak or health concerns by the employees, how you handle your data privacy issues relating to COVID-19. Communication is extremely important. You're going to have to advise and train the employees if you haven't. If you have, you still must have a written policy. The only way that you can measure compliance and understanding is an acknowledgement similar to the acknowledgement that you have in a handbook or policy document. So let's talk about the new liabilities that are here and are coming. The issues that we're seeing more prevalent than not now is accommodation requests and legal action relating to failure to properly accommodate those who are fearful of COVID. It's been a bonanza for the plaintiffs bar. Outbreaks in the workplace and how you handle information concerning anonymizing the individual who may or has COVID, uh, ensuring that that individual properly self-reports on COVID, and protecting that anonymity, even in small business operations, because it's required. And layoffs in the fourth quarter. Uh, the plaintiffs bar tolerated them in the second, but they're coming back hard in the fourth. So let's go over again some more basics on accommodation. Anyone discloses a health condition, treat it like an accommodation under the FFCRA, even if you would have treated it differently under the ADA. Why? Because that's the kind of condition that we're in under the FFCRA, particularly in light of the fact that we used to treat this issue very, very strongly when the accommodations related to a disability that the employee brought to your attention, COVID symptomatology, feeling ill, feeling fearful, having mental problems associated with COVID. This is unknown territory, and it needs to be handled or managed properly. I'm sure most of you on the call are having your HR people look at this seriously. If not, you really need to. Again, the person's position, their medical condition, what the business needs to do to get them operating. Those are the fundamental concerns about reasonable accommodation. Again, the EEOC is adamant that you cannot disclose the identity of the individuals who have COVID, who have contracted COVID, because it is considered a disability, and therefore you have to anonymize the information, which becomes a massive problem where you have a company that could stand to do contact tracing, but contact tracing is a daunting challenge because who you advise in a division or a department has COVID, even saying it's just someone, could lead to identity problems and therefore flagging the issue as an ADA violation. We're recommending now, similar to what a lot of the schools are doing, is they're doing contact trace pairing, where they identify really the group that may have come into contact with the person and then advise them to go out on quarantine. Not easy in a small business that doesn't have defined groups or units, or where an individual, traipses through the physical operations and then a week after they've done so, fesses up and indicates that they have COVID. We believe that employees refusing to work is going to come back as you get the $600 checks in. They're going to say they would rather be on unemployment than actually working. Again, the way to handle that problem, to put it the easiest way, is to treat it as a voluntary quit. That's how you get them back to work. I'm available to discuss that with anyone who has questions about that process. The brand new issue that many employers haven't come to grips with yet, which may or may not follow you to the state in which you're operating, is this new presumption that you contracted COVID in the workplace, which radically transforms how workers' compensation works. And let's remember, if it's a workers' compensation rather than a leave issue, all expenses would be covered by workers' compensation. The good news is that a lot of these changes are forcing the workers' compensation carriers to maintain your rating. So the fact that you may get hit with multiple workers' compensation claims should not adversely affect your ratings. There are currently 17 states that have modified to some extent, not to the extent of California, New Jersey, their workers' compensation to address COVID. Normally, workers' compensation, when it comes to a disease, must be an occupational disease. That is no longer the case in New Jersey or in California, as we'll see in a minute. Managing outbreaks is a massive liability issue how we hold on to the information or what we do with the information is an issue. Discrimination, hostile work environment, accommodation issues. This is a new channel for the plaintiffs bar. They are very effective in leveraging it. Everyone who is being fired, unless you've properly documented why, if you tell them that it's a COVID-related layoff, they will go to see a lawyer if they haven't done so already. And vaccinations as a new safety protocol, it's going to be all the rage. The defense side is on somewhat of a complicated schism as to whether and to what extent the vaccinations should be mandated. They could be mandated. However, there will be all kinds of ADA issues that relate to that as to whether or not the person has a medical condition. We believe that the vaccines will not be live. So it shouldn't, in fact, impact those who are immunocompromised. But until we actually have it, we won't know. Suppose the good news, if there is good news here, is that we should have up to 100 million doses by the first quarter, if you believe the news coming out of Pfizer. The irony is that what Pfizer also said, which was news to me until I looked it up, is that because the vaccination may actually come in multiple doses, there will only be, believe it or not, 15% of the population in the United States that will be capable of being fully vaccinated by March. Not great statistics. So you've gotten through your second quarter, you did furloughs. Your business was doing fine. All of a sudden you decide now is time to jettison employees and use COVID as otherwise a legitimate justification for the layoffs. The lawsuits are coming, they're coming hard. The argument that the plaintiffs bar accepted in March of this year for layoffs and damage in an unknown, uncertain world no longer exists. I'm finding many of the demand letters that are being directed at our clients at the firm are specifically attempting to anticipate a response that there were specific financial constraints or issues related to COVID. So I asked, why is this happening now? It's because in a normal market, it would be hard to find a job in the fourth quarter for most sectors. In a COVID market, it's impossible. The cold weather is going to bring a lot of uncertainty. We're going to see continued spikes in almost every state. There are only 2 or 3 states that still have low numbers. One of them is Hawaii. I think one of the other ones is Vermont or North Dakota. Those numbers are all going to change. We expect with the Thanksgiving and Christmas holidays, we're going to see record numbers everywhere, and employers are just going to be playing bunker mentality to watch how the rest of the year goes. And that's why we're going to see record unemployment and much lower hiring numbers. If you are planning to do layoffs this quarter, hopefully you've done them already, but the messaging is critical. Why are we doing this now? And everyone obviously knows if you're doing mass layoffs, there are certain requirements that by the Age Discrimination and Employment Act. For anyone who's firing 2 or more over the age of 40, you need detailed schedules under the ADEA. Otherwise, the age-related dismissal claims under a release will be forfeited by you, and you'll find yourself paying severance and still getting age discrimination lawsuits. This is one of the 2 bills that I focused on during the presentation. This is the New Jersey presumption of workers' compensation applying to a COVID-related injury. What I've done is highlighted, for those who are interested, the specific language of the bill that passed. What was particularly troublesome to me is the gloss overs of things like financial services. The fact that there's been yet no court interpretation of the document would suggest that, for example, everyone from bank tellers to your stockbroker, if you're in physical proximity, could use this to establish that they have workers' compensation coverage for COVID. The examples below, which the governor gave and which was reported to the press, don't cover those issues, which is interesting. They're covering basically your Starbucks employees or your grocery employees or those in the pharmacy. But it's a very wide-reaching law. And I think when we see financial services in there, or let's say hotel and residential services, it gives me a lot of concern that we're going to have, again, a number of employees complaining that they fall within these rubrics and therefore all of their costs are covered by workers' comp and they're treated as a workers' comp injury rather than simply an FFCRA or a standard leave issue. California, as with most things relating to employment, is far, far worse on this issue, ladies and gentlemen. All California employees are covered by this law, and it applies to any business that has 5 or more employees. This is an add-on to the governor's executive order, which operated before July 6, 2020, and was then codified in the law by Senate Bill number 1159. What it basically says is that there is a presumption if there is an outbreak in the workplace and 4 or more contract COVID, if you have under 100 employees or 4% if over 100, and you contract it within 14 days of a day after July 6 at the employer's place of business and at their direction, there is a presumption in favor of the fact that you have contracted COVID as a workers' compensation matter, and the state directs the Workers' Compensation Board, the WCB, to consider this a workers' compensation injury. Big change, big issues, no answers. And we're waiting to see. This bill came into effect the end of September. Too soon to call what this will do, how impactful it will be. I suspect that's going to depend upon whether these physical managed businesses post July 6 got the message and put all the right protocols, whether it was temperature testing or health screenings, into place. I put this on all of my presentations in case it's not familiar to every one of you in your businesses. But there is a specific form of insurance called employment practices liability insurance. Most of the carriers are scrambling to change their policies to add COVID riders just so they can add to your premiums. But they will provide or support coverage for claims that relate to COVID in the workplace, whether they're discrimination claims, failure to hire claims, toxic work environment discrimination claims. I would run out, if you haven't had a liability issue impact your workplace yet, the best time to do it is when you have an absolutely impeccable or clean record. So please run out, talk to your brokers, check in with your carriers. If you have a PEO policy, please read the fine print. While they promise to provide EPLI, usually the EPLI coverage is extremely limited. Some plans do not include defense costs, which can be a disaster for an employer that somehow thinks it's going to get a top-notch law firm, proposed by travelers, when in fact you still have to deal with all of the defense costs associated with it, and they're only willing to pick up liability and also only for a certain cap. A lot of EPLI coverage is capped at $1 million, and you absolutely want more than $1 million in coverage right now. The health and safety acknowledgement, this was like a rudimentary form that came up and has been further perfected by a lot of employment lawyers, including our firm. I've seen a lot of these kind of health policies even implemented by hoteliers today, where you advise that you're not currently suffering from any COVID symptoms, you haven't been exposed to anyone who has COVID, none of your family members have COVID, etc. The interesting thing about these policies is now the governor appears to be suggesting, as part of what he calls his daily mandate that you do these health screenings. The specific language that the governor is using is the following. Prior to each shift, doesn't specify shift, but let's assume it's a work shift of 8 hours, conduct daily health checks of employees such as temperature screenings, visual symptom checking, self-assessment checklists, and/or health questionnaires consistent with CDC guidance, including latest CDC guidance regarding COVID-19 symptoms, consistent with the confidentiality requirements of the ADA, NJLAD, which is the New Jersey Law Against Discrimination, and any other applicable laws, and consistent with guidance from the Equal Employment Opportunity Commission and the New Jersey Division on Civil Rights. What does this mean? Well, if you were going to implement a daily health check, what that would mean is you'd have a form like this every single day. It's probably not lost on anyone how dangerous it is that the governor has now forced the requirement of policing for COVID on the employer. The good news about the health form is that the health form is putting the policing on the employee. They are requiring to certify to their health conditions. They could do that certification every single day. They could do it in a way that also indicates that if their health condition changes, that they promise or certify that they are going to report that condition back. That shifts the burden, which is so important, from you to them. Again, if you are negligent in your policies, whatever they are, and you allow COVID into the workplace, for example, you have a form come in, or rather, let's use an even better example. One of your employees fails to submit a form that day. If you ignore the problem, and God forbid that employee has COVID, you've created your own negligence problem in the business. You've not informed your employees of a COVID situation potentially. You don't know whether that employee has COVID. If they do, then they've basically run rampant in your workplace and you haven't self-policed. There's a liability exposure issue right there. Really important, whatever your policies are, you need to formalize them and codify them. Why we're talking about having an operations manager, because there's no way, even in a small business, that the manager who's desperately trying to keep the business together, meaning the owner, is going to be able to effectively do every job, including getting out there with forms and making sure they all come back. So where do we go from here? What are we going to do going forward this year into next year? This is the best guidance that I think I can provide in one slide. If you don't have a compliance plan, if you haven't put it to paper, if you've basically just had a committee come up with ideas and you've talked about it and you've put it in some emails, you haven't done nearly enough. This plan needs to be as detailed as your handbook would be, as a separate rider to your handbook that applies during COVID conditions. It should include everything from what happens if people go out on travel advisories and vacations to what happens if they contact or contract COVID. And look, let's face it, if the employee has been negligent, you can take disciplinary action against them. Make examples of those who are not following procedure. HR or some kind of a response team within your organization is indisputably what's going to save your business from disaster and what might mitigate against an outbreak. You have to have it. You have to read the EEOC guidelines. You should look at them every week, or have your people look at them every week, because they're going to be updating them almost every week. And certainly when the vaccines come in, we're going to see all kinds of new guidance from the EEOC about employer measures with respect to the vaccines. Unfortunately, I don't think we're going to see that anytime soon, as while 94.5%, which is what Pfizer says its vaccines may be accurate on, who's going to be within that first round? What will the side effects be? How do we handle that as an employer? If we ask nicely, is that enough? Probably not. And so that's probably the number one issue I think that everyone on this call is going to face as an employer or business owner next year. State briefings are really important. If you are in New Jersey, I will tell you that what usually happens is the governor speaks, and within 48 hours, where he speaks on an issue involving COVID restrictions or relaxations, there is an executive order to follow within 24 to 48 hours thereafter. They are also available on the nj.gov website. I would follow them closely. At the firm, we follow them religiously. If there's a big update, we usually will have it out as some kind of a flash on our LinkedIn or on our website as well. And now I'm going to open the floor to questions I know people might have.
So I'll get a couple of them. Some of them will be off topic, some of them not as much. So an interesting question is, we have a situation. What would he recommend it if an employee who has a doctor's note not to wear a mask in the workplace? However, it was a requirement for all employees to wear a mask at all times. So that's coming up on some businesses regarding what policies you can make and what exceptions can be to them, and how much leeway does an employer have to enforce those rules like that?
That's a really good question. I always tell my clients that they have to be the boss. So you have an employee who comes with a doctor's note that says that they're asthmatic and they can't use a mask. The first thing, of course, is it's any mask. I can tell you that there are some masks that are so breathable, you almost wonder whether they're too porous, but they still exist. You don't have to require, for example, that everyone wears an N95 or a surgical mask. So the first reasonable accommodation is always practical. Is there a mask that can be worn that the doctor will allow? For asthmatics, I can tell you that there probably are actually masks. If that fails and the doctor is adamant that the person can't wear a mask in the workplace and you can't virtually keep them around, then you can basically tell them that, I'm sorry, but we don't have a position available for you in the organization if you're unable to physically report to work. Now, here's the rub. Did you create a position description that requires the individual to do work in the workplace? Or is it something that could be done from home? It's just not done from home. That's a problem under the Americans with Disabilities Act, because unless reporting to work is an essential function of the job, you're going to get a plaintiff's letter like you wouldn't believe saying, I can perform this job effectively from home. Why won't you let me work there? You're treating me differently. Where reasonable accommodations include work from home, the agencies are taking this concept of work from home extremely seriously. So we have to assume, unless you can prove through a written job description that the person needs to be physically on call. For example, warehouse manager, right, where there are no cameras, right? An architect that must perform site inspections, or a physical job. Let's say you're working in a meat production company and the person needs to be hands-on. Those are examples where you could probably get around it without having a written job description. But ladies and gentlemen, the interesting thing about all this is it always starts with the basics and works from there. You should be looking very carefully at whether you have a written job description for every single position. If you see this issue coming, run out and get them done. You can do them after the fact. That's okay. Better to do them than not have them. I could tell you, for FFCRA guidelines and for audits, the federal government, the USDOL, Department of Labor, is looking for those position descriptions. So I get right on that.
So is it better to do the declaration screening form daily, or how often does that form have to be done by an employer?
So here's what reading between the lines with what the governor said. I think a combination of things would be the most helpful. I think temperature checks coupled with weekly health screenings is the best, because it's too much paper, right? So you create a form requiring them to certify to their health conditions each week, to report if that changes any time between the time that they certify to their health on one week and the next week, because we know with COVID, which is a problem, that you could be asymptomatic even after you're tested, you could then come up with it in the interim, in the spaces between your
Yep.
certifications. So I think that's the best way to track it. What's great about something like a temperature check is a temperature check is something that can be done instantaneously, provided you've got someone competent that's going to be flagging that and not going to be asleep at the switch.
Yeah,
But
so I can add a little bit on there. It must be done in the right conditions, which we
right,
spend a lot of other webinars. And the number one thing we like to stress is doing it properly so that the results are good versus just doing a test. And I can piggyback onto that and say, we have a question, should fever screening be done by employees or at home or on premise or a combination of?
I'll tell you from my perspective, it should be done by the employer. This is a gatekeeping function. I hate the idea of this kind of policing, but let's put it this way. You could get a certification of temperature tests by an employee, but then they would have to do it daily. And if they're going to do it daily, you might as well have them do the daily form. The risk that you run as an employer is that you really would absolutely have to trust the employees to do this properly if you're going to do temperature testing, right? In this case, if you're going to do the temperature testing, I would rather have the company do it reliably,
Yep.
right?
Yep, understood. Are public workplaces such as school districts exempt from the liability issue with the contacting COVID in the workplace? We have a lot of students
If
that are,
let's say you have a charitable or religious organization,
or even a public institution where there's COVID in the workplace, say as a teacher and a student has it, do they have the same liability issues, assuming that, say a teacher was to get it, that it was at the workplace?
well, I would say that workers' comp issue would apply. There was no exemption made, for example, in California or New Jersey for public institutions. So I would say that will become a liability issue for the schools, for sure. And it may explain why many of the schools in New Jersey, for example, that were physical presence and gave the kids an option of going online, the governor's office and the local boroughs have been putting enormous pressure on the schools to close. A number of the private schools I'm aware of have done so. They're respecting the governor's wishes, and they're closing through mid-December or later.
Yep. So in regards to travel, particularly vacation, what kind of requirements do you have to follow? I know there's quarantining in certain states. Say they're not traveling for work, but they're traveling for personal vacation. Can you put policies? Should you put policies around that? The quarantining, the
Absolutely.
2 weeks? Sorry.
So no, so here's what you're grappling with as an employer with this. Travel advisors are just that. They're not quarantine directives, right? When they say you should, it's really funny that the governor's own language was voluntary compliance is expected. What does that mean? Those 4 words, nothing. It means absolutely nothing. So you have to make the decision as an employer. If someone is going out, whether it's work or not work related, if they're taking vacation, they say, I want to go to Texas or New Orleans, where numbers are really higher than in New Jersey, and I want to come back and go to work. Knowing that they're going to be out of work, you can create emergency vacation policies to address this use of PTO. Some employers I know are actually excluding or restricting PTO. So if you go off and spend 2 weeks in Texas, you're doing it basically without pay. And when you come back, because we don't want you in the business, if it's a physical business and you can't work from home, you're not going to get paid for that time either. The
And
important thing to remember,
yeah.
that this is important to remember, for salaried employees, right? If they work 30 minutes in a week, they have to get paid for the full week. Right? That's a federal requirement. So think about that. When they come back, if they're capable of working from home, keep them out of the workplace. If they're not capable of working from home, you tell them, look, you're not taking this time as PTO. We're not allowing you to use it. You put that policy in advance of use. I suggest to you that since we're in mid-November, if you want to make that a really fair policy and your PTO runs year to year, that you make that your 2021 vacation policy.
Gotcha. Great. Let's see how many more we can fit in. I know some of this might be hard to answer, but if a state allows no more than 10 people gathering in a group, um, actually, let me skip that one. Sorry, I'm on the wrong question here. Yeah, so if you have a 5-person limitation of a gathering in your state, does that mean face-to-face colleague classes or anything inside of a company needs to follow that as well?
There has never been a correlation, to my knowledge, between what they refer to as gatherings and what they refer to as business. If they were to do that, for example, it would shut down every industry, including every essential operation business, right? You
Correct.
couldn't have 5 people put car parts together, as an
Yep.
example.
And that's the same for
So,
schools. Schools are
right.
under their own
Right. So
guidance.
gatherings has been always interpreted as a social event, to the best of my knowledge. But of course, states may vary. Some governors may have a different vernacular than others. So you'd have to look at it. But by and large, gatherings does not mean congregation in a workplace.
Gotcha. So for a company that's already doing self-assessments, as part of the procedure, is there, people are asking about cleaning and disinfecting, and I think very specific questions. So rather than, can you address what you recommend in terms of an overall strategy? Meaning, so
Yeah, the great thing is
yeah,
there are a lot of third-party companies that actually do this now, which is nice. Um, CDC has guidelines about what happens when an employee at a site has been diagnosed, so you should take a look at what those are. I would talk to the third-party cleaning companies that are really the commercial ones. Um, but they've been identifying, for example, in the executive order, they've gotten somewhat granular on this, that high touch areas must be routinely cleaned and disinfected. So it's common surfaces, safety equipment, handrails, all touch surfaces. We've made recommendations to some of our clients that unless you absolutely need to maintain your, in-house kitchen or eat area, that you shut it down. Shut down the places where people are likely to congregate, because it's just better health and safety for the business itself. When things get better, you can start the coffee pot again. Go to Starbucks.
gotcha. Um, so if an employee contacted COVID-19, has quarantined for 14 days, tested negative, and now has a family member in the house or other members, can they still return to work?
So the hypothetical is, I was clean, but a
Yep.
family member has now contracted COVID.
Yes. And you're
Uh,
negative. So
right, and
assuming
you're
you got the
negative. So
antibody
right,
stuff, it's an interesting question. As time goes
it is.
on, the more and
Yeah,
more of this might happen.
and actually, I have this for a client. So person blew through all of her own emergency FFCRA leave, blew through her PTO, and blew through the New Jersey earned sick time. What else do they get? They get unpaid leave at home. And you should treat it that way, because you don't want that person coming back to work. Exposure in a circulated air environment where there's really no outside air is, inevitable. And sadly, what we're learning is that as the numbers increase, it is virtually inevitable that those around you are going to get it. And the best way to do that, and the thing that I would try to reinforce for your employees, if you even think there's an issue, stay home. The damage it does to the interiors of the workplace, the messaging, and all the other things that will distract you from making money are devastating to the business. I'd rather have the employees out. Another interesting issue that's come up recently is, what happens if you can't afford to have everyone in your business out at once, right? You have 20 people, there's a COVID contact issue within the workplace. What do? What I've suggested is you rotate the divisions or groups so that they're all getting tested without everyone getting tested the exact same day. So you rotate them through, have everyone that you can go home. It's a triage approach. It's not the best approach. Ideally, you'd have everyone leave the workplace together and come back only when they all got tested. But what do you do if that's impossible for the operation of the business? A thorny problem.
Yep. Well, I think we're just about at our time mark. Thank you very much for that presentation. I think it was very informative, and hopefully everyone got a lot out of it.
Thank you, everyone. It was a pleasure being here. Thank you for your time.
Take care.